Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. We are now solidly into the fall, and I got to tell you, I got to apologize. I know. It's been several months since we've pushed a new Legal Bites out, and I'm going to tell you what happened. I'm just going to be honest with you, and Monica here can verify this. We started doing this new Colorado Real Estate Commission position statement series back in the summertime, and we uploaded it to YouTube, and YouTube reached out and they said, hey, guys, we didn't anticipate that you would be doing a Colorado Real Estate Commission position statement series, and our servers simply aren't capable of handling all the clicks and excitement and page views that we're getting. So if you guys could take a few months off, give us a little bit of time to update our technology or catch up with you guys on Legal Bites, then we'll let you know and you can start doing the series again. And that's what happened. And Monica, you can confirm this, right? I'm deadly serious. They reached out to both of us and said, this is a problem with, you're crashing our technology with this series. But it's good to know that there's a lot of interest here. So we're back now, and I'm going to start pushing through a bunch of these. So be prepared, YouTube. Be prepared, you too. See what I did there? All right, so the first one, I'm going to go back now because we hit on, I think, 2, 3, and 4 commission position statements. I'm going to jump back to CP-1 now because at the time there was some pending issues to resolve with the Real Estate Commission. Those have since been resolved, and now I can talk to you about it. CP-1 addresses contracts provided by principals selling real estate. That title isn't probably great in some ways, but what it's essentially about is when you as a real estate licensee, as a realtor in Colorado, are using effectively non-commission approved, in most cases, contracts and the situations that might arise or where that situation might arise. Probably most commonly would be a situation, and I get a lot of questions on the hotline about this, a situation where you're representing a buyer, you take them to new construction, and the seller/builder is using their own new construction contract or builder contract or whatever it is. It's the selling principal who's using their own contract. So principal, as we know, is a party to the transaction. That's a buyer or a seller. They're the principals to the party. Unlicensed principals, so consumer buyer or seller, and builders, as an example, they don't have the same limitations that you do as a Colorado real estate licensee to specifically use the Colorado Real Estate Commission forms. And sometimes those forms aren't even appropriate, particularly in the case of new construction. So situations come up where, for whatever reason, and it's usually the seller, it's not typically the buyer who's trying to use their own contract, but it's the seller who is, maybe builder, maybe an REO kind of situation, some situation where the seller of real estate says, hey, I don't want to use the commission approved form, I want to use something else. All right? So when you're representing a buyer in that situation, the first thing that CP-1 addresses is the fact that you're free to work with that buyer. You can represent them in the transaction and assist them, but you cannot advise them. So you're not licensed. You're licensed to advise clients, buyers and sellers on the Real Estate Commission approved form. That's within your limited license to practice law. But in a situation where you're using a non-commission approved form, in this case a client approved form under our standard forms definition, you can certainly work with that buyer, you can represent them in the transaction, you can assist them, but you can't advise them on the non-commission approved documents that may be promulgated to them as you're going through the transaction. And in that case, you probably ought to, I would advise you as the buyer broker to do a writing or email or something to re-highlight or reflag to your buyer, listen, I'm not licensed to advise you on this form. Please seek additional legal advice or get some legal counsel if you are having issues, because I'm pretty limited with what I can do. So representing buyers is the first place they talk about. And then the next section that they talk about in CP-1 is representing sellers on builder contracts. So you're a listing broker now, and your client is a large home builder, maybe a smaller home builder, whatever it is. But they say, hey, we want to use our form. Maybe it's a bank in an REO situation. They say, we don't want to use the commission approved form. We want to use our form. And once again, you're entitled to use builder forms or your client's form at their instruction. When they say that, or when they offer you the form, you do, in order to be compliant with the standard form definition, want to save their instruction. In other words, when they send you a contract saying, hey, let's use this one on the transaction, keep that email sending that to you, and that would be proof that they instructed you to use that form in the transaction. So you're entitled, again, to work with the client. In that case, you shouldn't even be asked to advise the client because it's their form. Presumably, they've had their own legal counsel prepare it. They can be advised on the form with their own legal counsel. So it shouldn't even be asked of you to do. One of the things that they also point out, though, is often that same client that might tell you, hey, we don't want to use the commission-approved form, they might also say, we don't want to use the commission-approved exclusive right to sell listing contract. We want to use our own listing contract with you to engage you as our listing broker. And again, you're entitled to do that to the extent that you're comfortable signing their listing agreement. The one thing that the commission position statement 1 points out is that you do have to use the commission-approved brokerage duties addendum on any non-commission-approved listing contract. So there is a form that's an addendum that you would need to attach to your seller's listing agreement if you agree to sign and utilize that agreement. But that's kind of up to you because you're a party to that. In that case, you're a principal because it's a listing agreement. You're the listing broker and they're the seller. So, but make sure you're adding that brokerage duties addendum to that agreement. Once again, you can advise the seller on that non-CREC approved or you can advise the seller on the non-CREC approved contract, or I'm sorry, you cannot advise the seller on the non-CREC approved contract, but you must also advise the seller in times where the CREC approved contract is not appropriate, and that would be another situation like new construction. So I get this a lot. A lot of brokers will call the hotline and they'll say, well, I'm working with this seller and they're building a home for this buyer, and they'll ask me questions about, earnest money dispute or something. And I'll say, well, first of all, are you using the commission-approved contract? And in many cases, they'll say, yeah, that's what my client wanted to use. Well, the real estate commission-approved contract to buy and sell that you all use is meant for existing construction, not for new construction, speculative construction, construction that may not, or property that may not be delivered for months or even in some cases many, many months or years. That is not an appropriate contract. It simply doesn't contemplate all of the issues that may arise during a build period before closing. That is something that is perfect for a home that is existing that is being sold to somebody else who's buying that existing home. The home is already finished, it's in place, being transferred from a seller to a buyer. Not great for builders. And so you should advise your builder clients if they're saying, hey, that's the form I want to use. I would send them an email in writing saying, hey, this is probably not the appropriate form. You might want to get a more appropriate builder contract. At the end of the day, if that's what they're instructing you to use and you've given that advisory, it's hard to tell your client no. So anyhow, but in the case you're using that non-commission approved form, like a builder contract representing that seller, you're free to insert transaction-specific information. So they can say, hey, here's our contract. We want you to use this one. It's a builder contract. You could put in purchase price, closing time frame, buyer name, seller name. All of the transaction-specific stuff you are licensed to complete in your client's form, but you can't advise them on it. And you can't draft additional provisions or clauses or anything else because that should be done by your seller's attorney. So anyhow, there's that. Last part, the third part that CP1 addresses is when you're selling your own home as a broker or buying your own home. It really the same situation would apply. But again, it's mostly not the buyer who's initiating their own contract. The contract to purchase real estate is most typically directed by the seller. So selling your own home, first of all, you have to disclose in the contracting instrument or other contemporaneous writing. I would just encourage you to put it in the contracting instrument, your license status. A statement in the contract, if you're a property owner and you're leasing property, your lease, that's the contracting instrument. You need to disclose, hey, landlord and or seller is a licensed real estate broker in the state of Colorado. It needs to appear in the contracting instrument. That's the best place to put it as opposed to some other contemporaneous writing. And then what forms can you use? Well, remember, a principal can really choose to use their own forms. And so if you're marketing, here's how they landed on this particular rule in CP1, or in this particular advisory, I should say, in Commission Position Statement 1, is that if you're marketing your property, your own home for sale, through your brokerage firm, then you need to use the Colorado Real Estate Commission approved contracts, okay? If you're marketing your property outside of your brokerage firm, in other words, you're not using your brokerage firm to market your own house for sale, you're doing it yourself as an individual, then you can use whatever contract you'd like to use, because in that case, you're a selling principal that is acting outside of your brokerage firm, and therefore you're entitled to use your own contract to buy and sell if that's what you'd like to use. Now, my question there would be why, whether you're marketing your property through your brokerage firm, outside of your brokerage firm, if you've got existing construction and you're selling your home, why not use the commission-approved form? It's a pretty darn good form. It's available for free to you. It's been well vetted. You're familiar with it, comfortable with it. Most buyers and buyer brokers are comfortable with it. So probably use the commission-approved form. But as a matter of principle, you do have a right to use a non-commission-approved form if you're selling your own property and you're doing it outside of your brokerage firm. But the answer to that might lie in your office policy manual. In other words, some brokerage firms allow their licensees, their broker associates in the brokerage firm, to sell their own properties outside of the brokerage firm. Some of them specifically preclude it and require any real estate transaction that a broker associate within a brokerage firm, it has to be run through the brokerage firm, not outside of the brokerage firm. So before you make a decision in selling your own home, consult with your brokerage firm or your office policy manual, determine what you're allowed to do and not allowed to do within your brokerage firm. That's it, guys. That was a long one. Sorry for that. But hey, it's been a while since we've spoken. If you've got questions about how to use non-commission approved contracts or anything else, use the Colorado Realtors legal hotline. We'd love to hear from you there. And we will see you again on, you won't have to wait as long, the next edition of Legal Bites. Thanks so much.